We're taking you to Vancouver, where BC's Attorney General is reacting to today's pipeline decision. The province's Court of Appeal has shot down the province's proposed law that would have effectively blocked the Trans Mountain pipeline expansion. Let's listen.
The government said from the outset that we would stand up for British Columbia's environment, our economy, and our coast. Thousands of jobs and billions of dollars in economic activity would be put at risk by a diluted bitumen spill. While we're disappointed with the decision, we strongly believe the court has an important role to play in upholding the rule of law. That's why we referred this case to the court system in the first place. Our government always said this case would likely be heard before the Supreme Court, and in fact, we asked the federal government to join us in a direct reference to the Supreme Court of Canada. We continue to believe that we have the authority and the responsibility to protect our environment and economy, and so we will be exercising our right to appeal to the Supreme Court of Canada. I'll be happy to take any questions you may have.
Laura King, Canadian Press. Was this the largest tool you had in your toolbox, so to speak? And now that this has been struck down by the BC Appeal Court, what are the other tools you can use to block or delay this pipeline agreement?
So this regulation and the proposals around it are aimed at protecting British Columbia's coast and our environment from the catastrophic effects of a diluted bitumen spill. We believe that we have the right and the authority, constitutionally, except where the federal parliament says we don't, to regulate harmful substances that are brought into British Columbia, however they get here. Now, the Court of Appeal has said that it is their opinion that where our regulations specifically impact products brought in through an interprovincial pipeline, that proposition is not the case. We think this is something that could be clarified by the Supreme Court of Canada. There are many steps that our Environment Minister has taken in relation to ensuring that British Columbians are protected from diluted bitumen spills, including from railways. And this is just one piece of what the province has done to ensure we're protected, but we do think it's a very important piece.
Do you consider this?
Sorry, just one follow-up. So your government still opposes the Trans Mountain pipeline expansion. I know that you say this legislation is about protecting the coast, but what are you going to do to stop the pipeline expansion at this point, specifically?
So the aim of this regulation is to protect our coast and local jobs and wildlife from the catastrophic effects of the diluted bitumen spill. And that is what it is aimed at. We believe that we have the right and authority to regulate substances that are brought in, including through interprovincial pipelines, which is where the court and our position parted company in this decision. We would like clarification from the Supreme Court of Canada on that question. And we think it's critically important as elected officials in British Columbia, elected to protect British Columbians' interests, especially economic interests, to ensure that we have the protections in place to prevent a catastrophic spill.
So this has been a unanimous decision by the Court of Appeal. And many of the constitution lawyers, experts have said that there is no chance BC government is going to win, other than yourself believing it. So how much money we have spent on this, and where is the stop to using taxpayers' money to do a Goliath, David versus Goliath kind of legal battle?
Well, there are a number of points within your question that I disagree with. And for starters, there is certainly authority for the proposition we were arguing in front of the court, which is that British Columbia has the ability to regulate harmful substances brought into our province, including through railways or interprovincial pipelines. The court disagreed with us, but I don't agree with your suggestion that the only people saying that we had this authority were the BC government. It's not the case, simply not true. But what I would like to say is that in terms of the costs, the financial cost of going to court to clarify this question, to clarify the extent of our jurisdiction, it is a fraction of the cost of a catastrophic diluted bitumen spill in terms of the impacts on economy, on jobs, and just cleaning up the mess. So we think it's worthwhile in terms of clarifying our ability to protect British Columbians from this catastrophic outcome.
Any more questions from the floor? We're going to see if we have questions on the phone. Everyone please stand by. Oh, sorry. While we're waiting, we'll go to CBC. Tanya?
Hi, Attorney General. Could you speak about, you referenced in this case 3 specific questions. The courts found that because the first question on jurisdiction was a yes, it was basically they didn't need to rule on the following 2 questions. What do you have to say about that process, or how will that look now at the Supreme Court of Canada?
So there were 3 separate reference questions that were sent to the Court of Appeal for them to provide an opinion on. And they found that because the core of the law and their finding was directed at product coming in through an interprovincial pipeline, and specifically diluted bitumen, which is a product that comes in through the pipeline and then or by rail and then exits for export, that BC couldn't regulate, and so they didn't need to provide any opinion on the other questions. It's not unusual for a court where they find on one of the first questions an answer that means they don't have to provide an opinion on the other questions, that they limit their decision to a single question. In terms of the ability to appeal, the right of British Columbia to appeal, the Supreme Court of Canada has the ability to consider all 3 questions again.
And that is the Attorney General of British Columbia confirming that the province is going to appeal the BC Court of Appeal's decision to the Supreme Court of Canada. The Court of Appeal ruled against the province in terms of having jurisdiction, or in terms of being able to block the expansion of the Trans Mountain Pipeline project on environmental grounds. Keegan Pepper-Smith is a staff lawyer with EcoJustice. The environmental law charity made submissions before the BC Court of Appeal on this case. So first, Keegan, your reaction to the ruling.
Yeah, thanks for having me on. So, you know, as lawyers for EcoJustice, we would say that our client is disappointed with the ruling. This case for us was about whether the province has the constitutional authority to ensure communities and the environment are protected from potentially catastrophic oil spills. And the court in this particular case said that it doesn't have the authority to do so. And we think that's wrong, and that's disappointed, and British Columbia should be disappointed about that as well.
But the court was unanimous, right? I mean, they feel as though the court says that the province has no jurisdiction to enact legislation that would restrict the contents of the pipeline. So does this make this a purely federal project because it crosses provincial boundaries?
So we're still digesting the decision, of course. It just recently came out, but I would say that it doesn't go that far after our initial readings. It seems to us that the court was really careful to confine its reasons to these particular amendments. As your viewers will know, the initial approval had numerous provincial conditions, including permits that attach to that regulation of the pipeline. And we would say that those would continue to apply going forward if the project is reapproved.
The federal government and Alberta argued the law was nothing but a bid to delay or prevent the construction of the $7 billion pipeline. What's your reaction to that?
Quite frankly, I think that's just rhetoric. This case was never about trying to prohibit the Trans Mountain expansion from being developed. The Attorney General and BC government recognized that, and what they did in recognition of that is try to take steps to protect the environment and our communities from potentially catastrophic oil spills. And so we won't engage in that kind of rhetoric. I think it's more just about protecting us from potentially catastrophic oil spills.
What would you say is the likelihood, though, that the Supreme Court of Canada will hear this appeal, given that this Court of Appeal unanimously ruled against the British Columbia government?
Yeah, so it's our understanding, and I don't want to say this without some hesitation, but is that if the Lieutenant General in Council decides to appeal to the Supreme Court, which I believe you just had the Attorney General of BC on saying that they were going to do so, they have a right to appeal. So it's incumbent on the Supreme Court to hear this appeal. Okay,
yes, and I just want to make that clear that the BC Attorney General, David Eby, does confirm that the province is going to appeal to the Supreme Court. So you think that that is the right decision, but do you think, based on other decisions, similar decisions, in terms of the unanimity of the Court of Appeal's rejection of the BC government's case, do you think that the Supreme Court of Canada will hear this case?
Yeah, I believe they will. I think, in our day and age, when we're facing a climate and ecological crisis, when you have legislation directed towards protecting communities and the environment from further exposure to potential crisis, I think that, you know, that's a different analysis for the constitutional authority of the federal or the provincial government. And this is a case that strikes at the heart of those issues, and I think that the Supreme Court would be happy to hear that and make a ruling and direct us to go forward.
And what do you say, you know, some of the arguments that have been made, well, you know, there seems to be a lot of money that is being spent appealing what appears to be, at least in the decision of this court and others, arguably, federal jurisdiction.
Yeah, again, I think that's, you know, that's rhetoric that doesn't really appreciate the potential catastrophic impacts of an oil spill here in British Columbia in particular. You know, it may cost the government to do so and to appeal to the Supreme Court and to see if it does have the authority to protect the environment and communities, but that pales in comparison to what would happen if we had an oil spill that was subject to an inefficient and insufficient regulatory regime. And so I think it's worth every penny that the British Columbian government has spent thus far and will do if it does appeal to the Supreme Court to protect the communities and the BC government, the British Columbia coast and interior.
And you feel as though what the federal government has done in terms of some of their legislation around trying to protect coasts and dealing with potential spills and preventing spills, that it's just not enough?
Yeah, and so that was the heart of this reference case is, you know, the British Columbia government assessed what the regime was in place with respect to oil spill prevention, oil spill response, and oil spill remediation, and came to the conclusion that it didn't sufficiently protect British Columbia's environment and its communities. And so it asked the court if it had the authority to supplement that regime with stronger measures to ensure there was adequate protection. And so I think that's a really important question to get clarification from the Supreme Court on.
All right. Keegan, thank you. That is Keegan Pepper-Smith, a staff lawyer with EcoJustice in Vancouver.